Right, and coming to this chapter, that is chapter number is Competition Act 2002. In this Competition Act, we'll divide this act into 5 categories. The 5 categories: first category is the introduction and definition, and second category is the transactions, and third category is Competition Commission of India, fourth one is appeals, and fifth one is others. Right, what are the categories? Introduction and definitions, Competition Commission of India, transactions, appeals, and others. And coming to the first introduction part, previously the part is before this act there is an act that is monopolistic restricted trade practices act, and that the coverage, the scope of that act is very limited to the monopolies, and the competition act scope has been widened. Right, and coming to the definitions, the definitions we have acquisition, agreement, goods, consumer, enterprise, cartel another important definition, and person. Right, what are the definitions? Acquisition, agreement, goods, consumer, enterprise, cartel, person. This is about the first category, that is introduction and definition. Coming to the second category, that is transactions. In transactions, we have three important transactions. Right, the transactions are as follows: like anti-competitive agreements, combination, abuse of dominant position. Right, anti-competitive agreements, combination, abuse of dominant position. These are the main three transactions in this particular act. That is section 3 anti-competitive agreements, and section 4 abuse of dominant position, and section 5 combinations. And there are inquiry about these combinations, inquiry into the affairs of the anti-competitive agreements and abuse of dominant position. These two, that is anti-competitive agreements and abuse of dominant position, inquiry will be same, and inquiry of combination will be different. And orders by the commission after inquiry into the agreement or abuse of dominant positions will be same, and also orders of in respect to the inquiry and investigation of combination is different. Right, these are three transactions. What are the anti-competitive agreements, combinations, abuse of dominant position? Section 3 is anti-competitive agreement, section 4 is abuse of dominant position, and section 5 is combination. And coming to the next one, that is CCCI, Competition Commission of India. Competition Commission of India has composition, characteristics, establishment, meetings. Competition Commission, right, we have composition, characteristics, establishment, and what are the meetings of commission, when the meetings will be held and how the meetings will be held, and the resignation, removal, suspension of chairperson and other members of the Competition Commission of India, restriction on employment of chairperson and other members, and a selection committee. In Competition Commission of India, we will discuss the composition, characteristics, establishment, meetings of commission, resignation, removal, suspension of whom, suspension of chairperson and other members, and restriction on employment of chairperson and other members, and selection committee. And coming to fourth category, the appeal structure is a Competition Commission of India, next is appellate tribunal, and next is Supreme Court. The time gap is 60 days, right? If the order of the, if any person is agreed with the order of the Competition Commission of India, he has to go to appellate tribunal within 60 days, and if any person is agreed with the order of appellate tribunal, he has to go to Supreme Court within 60 days. And coming to the next one is others. In others, we have the power of central government to supersede the commission. This same power we have discussed in SEBI, SURFACI, SCRA Act also. You can check this, the power of central government to supersede the commission. Here the commission is CCA, Competition Commission of India. That is section 56, one of the important section, one of the expected question this time. And also next one is the power of commission to regulate its own procedures, and interim order of the commissions, appearance before the commission, rectification of orders of commissions, execution of order of commission, imposing penalty. These are the miscellaneous topics, that is other topic we are going to discuss. What are the other topics? Power of central government to supersede the commission, power of commission to regulate its own procedure, and interim order relating to the interim order of commissions, and appearance before commission, rectification of orders, execution of orders of commission, imposing penalty. Right? These are the 5 parts we are going to divide this chapter, and we are going to discuss right now. Right, and coming to the introduction and definition. In definitions, we'll start with the definitions chapter. Right, and coming to the definitions part, that is acquisition. First we'll see the definition of acquisition. Acquisitions means directly or indirectly acquiring or agreeing to acquire, means acquiring or agreeing to acquire what? The shortcut word is like the keyword is SAC, SAC, SAC. Shares, A means assets, and C means control. What is the keyword? SAC, yes. Shares, A. Assets, and C, control. See the definition of acquisition. Acquisition means directly or indirectly acquiring or agreeing to acquire the shares, voting rights, or assets of an enterprise, that is A and A, shares and assets or a control over management or control over assets of the enterprise. This is about acquisition. Acquisition means directly or indirectly acquiring or agreeing to acquire shares, voting rights, or assets of an enterprise, or control over management or control over the assets of enterprise. This is called acquisition. And coming to the next one, the definition of agreement. Agreement includes, here the keyword is three keywords are there: arrangement, understanding, action. Arrangement, understanding, action. Agreement includes an arrangement, understanding, action in consent, whether or not such agreement, understanding, or action is formal or writing. Means that agreement or understanding, arrangement or understanding or acquisition may be formal or may be writing. Means that agreement need not be formal, need not be writing. If it is informal also, it is an agreement. If it is not in writing also, it is an agreement, right? Whether or not, it may be formal, it may be informal, it may be in written, it may not be in written, right? And coming to the next, that is whether or not such a arrangement, understanding, or action is intended to be enforceable by legal proceedings. Means that agreement need not, may be enforceable under the act or may not be enforceable by the legal proceeding. That means we can sue or it cannot be sued, right? The definition of agreement, once again we'll see the definition of agreement. The keyword is here arrangement, understanding, action. Agreement includes an arrangement, understanding, action in concert, whether or not such arrangement, understanding, action, that the three keywords: arrangement, understanding, action, is formal or writing. It may be informal, it may not be in written. Whether or not such arrangement, the three words, whether or not that arrangement, understanding, or action is intended to be enforceable by law, legal proceeding. It may be enforceable, it may not be enforceable, right? This is the definition of agreement. And coming to the definition of cartel, the cartel definition is important here. The definition, the keywords here is association and limit, control, or attempt to control, right? Cartel includes an association of producers, distributors, sellers, traders, or service providers who by agreement among us themselves limit, control, or attempts to control the production, distribution, sale, price, or trading goods or provision of services is cartel. Means like the keyword here is association, limit, control, or attempts to control. Cartel means the association of producers, like some producers will be formed in association, or some sellers will form an association, and they will control the production, distribution, sale, or price, or provision of services. Then such group is called as cartel, right? Once again, the cartel includes association of producers, sellers, distributors, traders, or service providers who by agreement among us themselves limit, control, or attempt to control, limit, control, or attempt to control the production. Even if they attempt to control, then also such group will be said as cartel. Attempt to control the production, distribution, sale, or price of the goods, or the trade in goods, or provision of services. That is the definition of cartel. And coming to the definition of consumer. Consumer means any person. Consumer, we have two types. First point is relating to the goods, and second point is relating to the services. Means consumer means any person who buys the goods, and consumer means any person who hires or avails the services, right? And also there has been one more person apart from who, the person who is buying the goods, another person who is using the goods is also said to be a consumer. And for that purpose, maybe commercial purpose or personal purpose or for resale purpose. Same as the case of services also. The person who avails of any service for consideration, and also person who is the beneficial receiver of the beneficial of such services is also the consumer. And such service may be for commercial purpose or for personal use, right? And here we'll see the definition of consumer. Consumer buys any goods for a consideration which has been paid or promised or partly paid or promised or partly paid or partly promised under any system of deferred payment. It may be paid, partly promised to paid, or any deferred payment, and includes any user. Here the keyword is user, right? Any user of such goods other than the person who buys such goods. If any person uses the goods also, then of that person shall be said to be a consumer. Any consumer of such goods other than the person who buys such goods for consideration paid or promised or partly paid or partly promised or any system of deferred payment, when such use is made with the approval of such person, whether such purchase of goods is resale or any commercial purpose, right? And such use shall be done after taking the approval of such person. Means the person who buys the goods, after the approval of such person, the other person uses the goods, then the other person will also be said to be consumer, right? Same is the case of service. Hires or avails any service for a consideration which has been paid, partly paid, promised or partly promised to paid, or any other deferred system, and includes any beneficiary of such persons other than the person who hires or avails the services consideration paid, promised, partly paid, same thing, and with the approval of the first mentioned person, whether such hiring or availing services is for commercial or for personal use, right? The important thing is the person, or the person who buys, or the person who uses, and the person who avails services, or the person who is the beneficiary of the services. It may be for resale, commercial purpose, or personal use, doesn't matter, he is a consumer. And for services, it may be for commercial purpose or personal purpose, because services cannot be resold, right? This is a case of consumer definition. And coming to the definition of enterprise, the definition of enterprise, will see enterprise means any person or department of government, even the department of government will be called as enterprise, and which is has been engaged in any activity relating to the production, storage, all the activities, whatever the activities the business and enterprise can do, all activities: production, storage, supply, distribution, acquisition, control of articles of goods, provision of services, investment, business of acquiring, holding, underwriting, dealing with shares, debentures, directly or indirectly to one of its units, division, or subsidiary, whether those units are located at the same place or at different place, such person or department of government will be called as enterprise. Means whatever the activities possible, you can write production, storage, supply, distribution, investment, right? Those services, that is called enterprise. And one more thing here, important point is, does not include any activity of government relatable to the sovereign functions of government. The keyword is sovereign functions. Does not include any activity of the government relatable to the sovereign functions of the government, including all activities carried on by the Department of Central Government dealing with atomic energy, currency, defense, and space. See, if these four things, they are the sovereign function. The sovereign functions here are atomic energy, currency, defense, and space. Like, these are the four activities that does not, if any government is doing, if the government is carrying on these four activities, then that will not be considered as an enterprise under this Competition Act 2002. What are the activities? ACDS, atomic energy, currency, defense, and space, because of these are the most important for a country to develop: atomic energy, currency, defense, and space. And coming to the next definition, that is definition of goods. Goods means goods as defined in the Sale of Goods Act 1930, right? This is the definition of goods. Goods means as defined in the Sale of Goods Act 1930, and includes three more things are given for the goods. What are the three more things? Includes products manufactured, processed, or mined. The products which have been manufactured, the products which are processed, the product or which are mined. Debentures, stocks, and shares after allotment. The keyword here is after. Means the shares after allotment can be called as goods under this Competition Act 2002. If the shares are before allotment, they cannot be called as goods. And third point is, in relation to goods supplied, distributed, or controlled in India, goods imported into India. Any goods which have been imported into India, these are also called as goods under this Competition Act 2002. See the definition of goods. Goods means the goods has been defined as Sale of Goods Act 1930, and includes three things: the products manufactured, processed, or mined, and the debentures, stocks, shares after allotment. The keyword after allotment. And in relation to the goods supplied, distributed, or controlled in India, goods imported into India. In relation to goods supplied, distributed, or controlled in India means what are the goods that are distributed, supplied, and distributed in India, and also the goods imported into India are also said to be as goods as per Competition Act. And coming to definition of person. Definition of person is not that much important, but generally the individual, HUF, company, firm, individual, HUF, company, firm, association of persons or body of individuals, whether incorporated in India or outside India, or any corporation established in the Central State Provisional Act, or government company as defined in Section 245 of the Section Companies Act 2013 is a person, and also a body incorporated by in India or outside India is also a person. A local authority and a cooperative society registered in the Law of Cooperative Societies Act is also a person, and every artificial judicial person not falling within any of the preceding subclass. Means the person definition here they have covered, right? And we have completed our first category, and coming to our next category, that is our Competition Commission of India, we'll see, right? In this section, that is Competition Commission of India, we'll see about the composition, the characteristic, the establishment, and the meetings of the Competition Commission of India, and the resignation, removal, or suspension of the chairperson and other members of the Competition Commission of India. What are the resignation, removal, and suspension of chairperson and other members of the Competition Commission of India, and restriction of employment, right? The chairperson or the other members have been appointed, and they have any restriction on employment with the enterprises, like that is the point, getting that restriction on employment of a chairperson or other members and selection committee. These are the things we are going to discuss in Competition Commission of India, right? And coming to this one, that is Competition Commission of India. Coming to this first one, that is establishment Competition Commission of India will be done by the central government in the official gazette. And coming to the characteristics of Competition Commission of India, what are the characteristics? Means Competition of Commission of India is a body corporate, and it has perpetual succession, and also it has a common seal. It has a power to enter into contract. It has a power to show in its own name. It has a power to acquire, hold, or dispose of property. Like all the features of a body corporate, it has. Competition Commission of India is a body corporate, right? And coming to the vacancies not to invalidate the proceedings of Competition Commission of India, we'll see this vacancy not to invalidate the proceedings in so many areas, like in our Companies Act. Also we'll see even in SEBI, Surface Act, SCRA, even in PML Act also we'll see this, the vacancies not to invalidate the proceedings of CCI, right? And coming to the first one, the vacancies due to the vacancy in Competition Commission of India, or the defect in Constitution of Competition Commission of India, that is the constitution, the composition of Competition Commission of India has not been properly filled up, or even the defect in appointment of a chairperson or a member of the Competition Commission of India, or there is an irregularity in the procedure followed with the Competition Commission of India, not affecting the merits of the case. In these four particular cases, that even though the proceedings is not according to this vacant, or not according to this act, then also they are not invalid, means they are valid, right? No act or proceedings of Competition Commission of India shall be invalid due to the reasons of the vacancies in the Competition Commission of India. Means any vacancy is there, for that reason the decision taken by the Competition Commission of India is not invalid. Or a defect in Constitution of Competition Commission of India, we already know the constitution means the composition. And defect in the appointment of chairperson or member, vacancy in Competition Commission of India, defect in Constitution of Competition Commission of India, and defect in appointment of chairperson or member, or any irregularity in procedure of Competition of Commission of India. Here important point, any irregularity, and the keyword is not affecting the merits of the case, right? And coming to the next one, the composition of commission. Here we in this act we will use the commission. Here the commission means a Competition Commission of India, is CCI, right? Composition of commission. The commission shall have a chairperson. One chairperson shall be there, and chairperson, if any vacancy in the office of the chairperson, then the senior most member shall act as a chairperson until the new chairperson assumes his office. Means, for example, there is any vacancy in the chairperson of office, and that place shall be occupied by the senior most member in that group, in that commission, until the new chairperson assumes his office, until the new chairperson is appointed by the central government, right? And the inability of the function of chairperson until the chairperson resumes. If any chairperson is showing some inability, means because of his personal reasons or because of his something, he is showing an inability to attend the function, that is the meetings of that, then the senior most member shall discharge the functions of chairperson, right? This condition we have seen in one more place, that is our SEBI Act. If you remember, that even if that any person is unable to attend the meeting of a chairperson, that any chairperson is not, any chairperson is not able to attend the meeting, then in that the members present in the meeting will choose a member to act as a chairperson, that is in SEBI. But here in Competition Act, it is the senior most member. That is one important difference. You may confuse, please remember that. And coming to the next one, that is other members. It has one chairperson. Other members, like it has a minimum 2 and maximum 6. That is minimum 2 and maximum 6. And coming to this common provisions applicable to chairperson and members of Competition Commission of India. What are the common provisions? Like who will be appointed, who will recommend these members, chairpersons? The selection committee will be that one particular committee will recommend, make recommendations of names of these chairpersons and members to the central government, and central government appointment of central government based on the recommendations will appoint these chairperson and members, right? And the nature of office, these the chairperson offices and members offices is whole time members, and the tenure is 5 years. Whether they can be eligible for reappointment, yes, they're eligible for reappointment. The maximum age is 65 years, right? These may be asked for MCQs. Maximum age is 65 years. Reappointment, yes. Tenure is 5 years. And oath of secrecy, that is the prescribed manner. Oath of secrecy here means they are confidential to that functions in the respective commission. And salary and terms of conditions as may be prescribed, like there are rules in particular, based on that rules the salary will be paid to the chairperson and the members. And the variation in the salary and terms and conditions shall not be prejudicial to him. If any there is any variation in salary and terms and conditions of the after entering, those conditions shall not be prejudicial to that particular person. Means a particular person here is the chairperson or the member who is going to be appointed in the commission, right? And also if any vacancy that arises in place of the chairperson or members, those vacancies shall be filled by whom? That is our boss. That is here the boss is a central government, filled by central government making appointment from a panel of names recommended by the selection committee. Right, the selection committee we have known. The selection committee will recommend the names to the central government, and central government will pick some member and will appoint as a chairperson or member if there is any vacancy. And coming to the qualification and experience, what is the qualification and experience of this particular chairperson members? Right, the person of ability, integrity, and standing. That is AIS. The person of ability, integrity, and standing who has special knowledge, of and such professional experience of not less than 15 years. So the experience will be 15 years or more in the following fields. Then only those person can be eligible for appointment of a chairperson or member. Like you should have the ability, integrity, standing, special knowledge, professional experience of not less than 15 years. That means 15 years or more. In what fields? We have a shortcut for remembering these fields. That is ABC Film SIPE. ABC Film SIPE. SIPE here is CIPE. Can be spelled as CIPE. ABC Film SIPE. A for accountancy, B for business, and C for commerce. Accountancy, business, commerce. ABC Film. That is FILM. Finance, Industry, Law, Management. Finance, Industry, Law, Management, and SIPE. CIPE. That is competition matters, intermediate, international trade, and public affairs and economics. Right, what are the areas that member or chairperson shall have of at least 15 years or more experience? That is ABC Film SIPA, accountancy, business, commerce, finance, industry, law, management, competition matters, international trade, public affairs, economics. That is ABC Film SIPE. SIPE can be spelled as CIPE. Right, and coming to the next one, that is resignation, removal, and suspension of chairperson and other matters. Right, these provisions are applicable to the chairperson and every member. Right, if any person wants to resign from his post as a chairperson or a member, then he has to give notice in writing. That notice shall be signed and it shall be addressed to the central government. Means if any chairperson or member want to resign from his post, he has to give a notice to the central government in writing. Right, and the chairperson or member to continue till, means even though the chairperson has given his notice, he shall be continued till the following conditions. Same we have seen in our SEBI chapter SAT, that is in case of a presiding officer is going to resign, he has to give notice, and also the three conditions are there, but here four conditions are there. That is securities appellate tribunal presiding officer or any member. Right, if he resigns, he has to continue the office the earliest of 3 months from the date of notice, or if any successor enters in upon his office or expiry of his term, whichever is earlier. There, in SEBI, SAT, presiding officer, or other member, there are 3 conditions, but here 4 conditions. The additional condition is permitted by the central government to relinquish his office sooner, earliest of the 3 months from the date of notice, or the successor enters his office, or the expiry of his term, or the permitted by the central government to relinquish his office sooner. Right, this until then the chairperson or member shall continue his office even though he has given notice of resignation. And coming to the next point, it is removal by the central government. In the same we have seen in our SEBI chapter, removal by the central government, the members of SEBI or the members, that is presiding officer of SAT. The same conditions are there, but they are in SEBI members and chairperson. The grounds are ICU abused, that is insolvent, convicted of moral turpitude, unsound mind, and abuse his position. Right, that is in SEBI, and that is in SEBI members and chairperson. And coming to the SAT, that is in SEBI chapter only, the securities appellate tribunal presiding officer, judicial person, technical member. Right, if central government want to remove them, the grounds for removal are ICU, abused, financial interest. That is first one, I is for insolvent, C is for convicted moral turpitude, U is for unsolvent, that is they have used differently, physically or mentally incapable of being acting as a member, that is same unsolvent. And next one, abuse his position. And next one is financial interest. The financial interest means acquired such financial interest or other interest as is likely to affect his prejudicially functions as a member. right? In that case, if these four conditions, if these are the four grounds for removal of the presiding officer, technical member, judicial member of the SAT in SEBI. And coming to here, the Competition Commission of India for removal of the chairperson member, there are 5 conditions. The shortcut here is also same, but ICU E ward means ICU. There is different words will be there, right? ICU E ward, abuse to financial interest. Abuse is financial interest. That ICU E, abuse is financial interest. And I is for same, adjudged as insolvent, and C is for convicted of an offence involving moral turpitude, and U is for the answerment that is differently used here, that become physically or mentally incapable of acting as a member, right? And E is for, that is E word, E is for engaged in any paid employment, these are the 4 cases, ICU E. In these 4 cases, without any inquiry, that is without any opportunity of being heard shall be given, and then without any opportunity of being heard to be given to the members, central government can remove. But the abused financial interest, the central government has to give the opportunity of being heard, right? That is abused his position such that his continuance is prejudicial to the public interest, or acquired such financial or other interest is likely to affect the prejudicially his functions as a member, then in this case, right, it can be removed, but inquiry shall be conducted. Removal of central government after inquiry by the Supreme Court cases and the procedure of inquiry. The central government shall refer the matter to the Supreme Court, and Supreme Court will inquire into this matter, and Supreme Court will form a report to the central government stating that the member and chairperson ought to be removed on the order of removal of central government, right? These are the 5 conditions for the ground for removal. And coming to the next one, the restriction on employment of chairperson and other members in certain cases. What are the restrictions? We'll see about the restriction. Means any chairperson, every member after cessation of office means they have left that Competition Commission of India, and after that they shall not be form part of any employment for a period of 2 years, that is a future 2 years. Enterprise which has been a party to any proceeding before the commission, means any enterprise which has come to that Competition Commission of India for any case, then in that enterprise this person after expiring of his office shall not be employed. But there is an exception in this case. The enterprise may be, if the enterprise is central government or state government or local authority or statutory authority or government company or corporation, then these chairperson member can be employed in these particular 6 companies, 6 body corporate, we can say central government or state government, local authority, statutory authority, government company, corporation, right? These are about the restrictions of employment on chairperson and other members in certain cases. And coming to the last one, that is selection committee. The selection committee, we said that the selection committee will recommend the names of these chairperson and members to the central government, then central government will pass an order for appointing these chairperson and members in the CCI. And what is the selection committee consist of? Composition. The selection committee composition is the Chief Justice of India or his nominee as a chairperson, or secretary in Ministry of Corporate Affairs as a member, and secretary in Ministry of Law and Justice as a member, and 2 experts as a member whose qualification are same as of our CCI member. The qualification same as CCI members means that is our qualification and experience, person of ability, integrity and standing, that is AIS, special knowledge and professional expertise in for not less than 15 years, that is 15 years or more in ABC film type, that is accountancy, business, commerce, finance, industry, law, management, competition matters, international trade, public affairs, economics, right? These are the qualifications of the members of 2 members. What are the composition of selection committee? Chief Justice of India or his nominee act as a chairperson, secretary in MCA, that is Ministry of Corporate Affairs as a member, secretary in MLJ, that is Ministry of Law and Justice, and two experts as a member. The expert members qualification same as CCI, right? And coming to the meetings point of Competition Commission of India, how the meetings of Competition Commission of India are going to be held. The number of meetings and procedure for meetings. The Competition Commission of India shall meet at such times and such places, and shall observe such rules of procedure in regard to the transaction of business at its meetings as may be provided by the regulations. Means they are not any specified, but at such places at such time they have given, that they may be given in the regulations, right? And coming to this decisions by majority. Decision by majority means see this the same we have seen in our PMLA, that is Appellate Tribunal section 38, I guess. In that, if you see if there is an odd number, the decision will be taken by majority, right? That is no, if it is an odd number, there is no problem. If it is a 5, then the majority is 3. If it is an even number 4, the 2 that votes may be tied, then in that case the chairman in PMLA, the chairman or the chairman can have a second vote, that is casting vote, or the chairman can refer this matter to any new member and then thus forming a new majority, right, in PMLA. But here all questions which come up before the meeting of a commission shall be decided by the majority of the members present and voting in the event of equality of votes. The chairperson or in absence member presiding shall have second vote. Here, if any the even number is there and the votes are tied, then the chairperson will have secondary, that is second or casting vote, second or casting vote. And one more important MCQ is what is the quorum for this Competition Commission of India. The quorum is 3 members. The quorum shall be 3 members. We may confuse with our Companies Act quorum, but here the quorum is 3 members, right? Right, and we have completed our part 2 parts, that is the introduction and definitions and Competition Commission of India, and we are going to the core part, that is the transactions in the Competition Act 2002. There are 3 transactions that will be covered in the Competition Act, that is anti-competitive agreements as per section 3 and abuse of dominant position as per section 4 and combinations as per section 5. And we'll see the inquiry into this particular transactions also, and we'll see the orders passed by the Competition Commission of India after inquiry and investigation. Right, and coming to our first one, that is anti-competitive agreements. Anti-competitive agreements has been dealt in section 3. These 3 sections shall be remembered because section 3, section 4, section 5 anti-competitive agreements, and section 4 abuse of dominant position, and section 5 combination, because they are very important and highly expected in examinations. Anti-competitive agreements, that is the first that is the first, that no enterprise or association of enterprise or persons or association of persons. We have already seen the definition of enterprise and as well as the person. See, no enterprise or association of enterprise or person or association of persons or between person and enterprise shall enter into any agreement. We have seen the definition of agreement also, that is in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which causes are likely to cause, that means present or in future, causes are likely to cause, that is present and future, an appreciable adverse effect on competition within India, then such agreement will be said to be as anti-competitive agreement, and such agreements are prohibited under as per the Competition Act 2002. Right, here the important word is appreciable adverse effect on competition within India. If the agreement is outside India, it is having appreciable adverse effect outside India, then it is not an anti-competitive agreement, right? The main definition we'll see once again. No enterprise, it is prohibited. No enterprise, first of all they are using negotiation, that is negation. No enterprise, enterprise or association of persons or association of enterprise or person or between person or enterprise shall enter into any agreement in respect of purchase, sale, distribution, storage, acquisition or control of goods or provision of services which causes present or likely to cause future an appreciable adverse effect on competition within India, then such transactions are called as said to be as anti-competitive agreements, and they are freely prohibited. For example, if any person commits this agreement, that is anti-competitive agreement, what is the case? Effect of anti-competitive agreements: any agreement entered into the contravention of the provisions of section 3 subsection 1 shall be void. Violating, contravening the section 3 subsection 1, if any persons enter into anti-competitive agreement, then such agreement is void as per the Competition Act 2002. Right, and coming to the next topic, that next one, that is per se anti-competitive agreements. Per se means they are deemed, they are by in itself or implied or deemed to be anti-competitive agreements if they fall under these categories. Like here the same thing has been defined. Any agreement we have seen the definition earlier, and it is an agreement, right? And it is an agreement between whom enterprise or association of enterprises, person or association of persons, or between persons and enterprise, like or practice carried on decision taken by any association of enterprises, including cartel. Even cartel includes here. And such they are engaged in what? They are engaged in identical or similar trade of goods or provision of services. The important keyword is here identical or similar goods or provision of services, which means these persons, association of persons, enterprise or cartel is engaged in identical or similar goods, and they do the following things. What there are 4 things they do, and they fall under per se anti-competitive agreement. The 4 things are they directly or indirectly determine the purchase or sale price, means they are determining the purchase or sale price, or the limits or controls, means we have already seen our definition of cartel. That same definition is given. The limits or control the supply, distribution, markets, technical development, investment, provision of services. The first point is they are determining the prices of the goods, and second one is they are limiting or controlling the production, supply markets, and the third one is the shares the market or source of production or so provision of services by way of allocation of geographical area of market, types of goods, services, or number of customers in the market, or any other similar way. Like they are sharing the market, that these persons or association of persons, enterprise or association of enterprise or cartels are formed, and they are sharing the markets, like this particular area you take and this particular area I will take, and these customers come to you, transfer to me, like they're classifying those markets to among themselves based on the following parameters, that number of customers, geographical area, based on the product and based on the services they are classifying. If they are doing this, it is an anti-competitive agreement. And also the fourth point is directly or indirectly results in bid rigging or collusive bidding, right, shall be presumed to be having appreciable adverse effect on competition. Means if these persons have done these four transactions, four items, then that agreement is said to presume to have the appreciable adverse effect on competition, and thus it is an anti-competitive agreement which is prohibited under Competition Act 2002. What are the four types? What are the four things? We'll once again see. They are fixing the prices, or they are limiting or controlling the production, supply, storage, whatever, and they are also sharing the markets based on the parameters like geographical area, number of customers, type of goods or type of services, and directly and indirectly they are involving in the bid rigging or collusive bidding, right. In these four items will be presumed to there and implied to be the implied to have appreciable adverse effect, and thus these transactions, these agreements will be named as anti-competitive agreement, which are prohibited, right. Right, and we have seen the bid in the fourth point directly involving the bid rigging or collusive bidding. We'll see the definition, what is bid rigging and what is collusive bidding, right. These bid rigging, different short notes on bid rigging can be asked for 2 marks, as the Competition Act is famous for asking definitions, right. And in our exams, bid rigging may be asked for 2 marks, and we will see the definition of bid rigging. Bid rigging means any agreement between enterprise or persons engaged in identical or similar. Here the keyword is identical or similar, means it is any person, same. Bid rigging means any agreement. I have seen the definition of agreement also. Agreement between any enterprise or person who is engaged in the identical or similar production, storage, trading of goods or services, which has an effect of eliminating or reducing competition of bid, or adversely affecting or manipulating the process of bidding. There are 4 things. Eliminating, first, that the bidding process itself eliminated. They have entered into such an agreement that the bidding is itself eliminated, or reducing competition of bidding. The second one, the competition, the bidding is reduced, or it is having adversely affecting the bidding process, or it is manipulating the process of bidding, right. If any person, enterprise, enters into such contract dealing with similar identical goods which affects the bidding process in the following ways: it eliminates, reduces the competition, adverse effective or manipulating the process. In this process, this agreement is called bid rigging or collusive bidding, right. And we have an exemption for agreements entered by the way of joint venture. For example, if any agreement entered by way of joint venture, then it will not be said to be an anti-competitive agreement. An agreement shall not be deemed to be anti-competitive agreement if it is entered by way of joint venture and it increases the efficiency in production. The main thing is it should increase the efficiency of production, storage, supply of goods, provision of services, or control of goods, right. The main thing here is, if an agreement is between a joint venture and it is not deemed to be anti-competitive agreement if it increases the keyword is if it increases efficiency, right. And there are certain other anti-competitive agreements. What are the other anti-competitive agreements? We will discuss. Any agreement among themselves, enterprise or persons, at different stages or levels of production chain in different markets, right. There will be different agreements entered by the persons in the production chain, that is from starting of the production goods to the sale and after sale. There will be some agreements entered by the purchaser or supplier or any other person. Then those agreements will be said to be anti-competitive agreements if such agreement causes or directly likely to cause, that is present or in future likely to cause, an appreciable adverse effect on competition in India. Then these transactions, these agreements will be said to be anti-competitive agreements. What are these types of agreements? We will see the levels of production chain, different markets. The type of agreements are as follows. There are 5 types. Tie-in arrangement, that is tie-in arrangements, and exclusively supply agreement, and exclusively distribution agreement, refusal to deal, resale price mechanism. What are the 5 types? Tie-in arrangement, exclusively supply agreement, exclusively distribution agreement, refusal to deal, resale price maintenance shall be an agreement in contravention of section 3 subsection 1 if it have causes or likely to cause have appreciable adverse effect on competition in India, then it will be said to be a contravention of section 3 subsection 1, that is anti-competitive agreement. It is prohibited and the such transactions are deemed to be void, right. And coming to the definition, we'll see one by one what is tie-in agreement, what is exclusive distribution, what is exclusively supply, what is refusal to do, what is resale price maintenance. First of all, tie-in arrangement means, for example, if any person is purchasing any goods, if he purchasing any one good, then there is a condition for buying that good. If that good shall be bought only if he bought another good, like means if a person wants to bought AC, he should purchase fan also. That such type of agreements are called tie-in agreements. Like we'll see the definition. Tie-in arrangement, which the definition includes any agreement requiring a purchaser of goods, means purchase, the person who is purchasing the goods, as a condition, means the keyword here is a condition of such purchase for buying that particular good to purchase some other good. Means for buying that particular good, he is purchasing some other good, then it is said to be a tie-in arrangement. That is includes any agreement requiring a purchaser of a good as a condition of such purchase to purchase some other goods. It is called as tie-in arrangement. And coming to the definition of exclusive supply agreement, exclusive supply agreement is like it is like restricting, it is like restriction. Like it is like having, it is like giving restriction to the purchaser. I mean, for example, A is the B is there, and A is the purchaser, B is the sell, B is the supplier, and A purchased goods from B, and B is imposing restrictions on this purchaser that you should deal only with my goods, or you should, or B is restricting that purchases, that A, you should deal with only that particular C only, you should not deal, you should not acquire any other particular goods, and then it will be said to be exclusively supply agreement. You see the definition includes any agreement restricting, the keyword here restricting in any manner, whatever the manner it may be, the purchaser, means the person who is purchasing goods, in the course of his trade from acquiring or otherwise dealing in any goods other than those of the seller or any other person. Means he is restricting from dealing or acquiring any other goods other than those of the seller or any other person. Means that person, that purchaser shall have to deal or acquire the goods of the supplier or any other person as said by the supplier, then it will be said to be as an exclusive supply agreement, right? And the main condition here for these agreements to be said to be as anti-conflict agreements, they should have appreciable adverse effect, right? If they don't have appreciable adverse effect on the competition, these agreements should not be treated as anti-conflict agreements, right? And coming to the next one, that is exclusive distribution agreement. Exclusive distribution agreements we'll see, right? And this is exclusive distribution agreement means that if, for example, the distribution, for example, that is the allocation, they will allocate some particular area, they will allocate some particular area, in that area only you have to distribute your goods and services. If any agreement is there, that is said to be exclusive distribution agreement, which is the definition includes any agreement to limit, they are limiting or restricting or withholding the goods output or supply of any goods, or allocate any area or market for the disposal of sale of goods, that they are having some distributional rights. This is called exclusive distribution agreement. These are said to be anti-competitive agreement if and only if they have appreciable adverse effect on the competition in India. And coming to the next type of agreement, that is refusal to deal. A refusal to deal here means that is no transactions can be done with any particular person. Means they will enter into an agreement that you should not perform with any transaction with that person. This transaction is said to be refusal to deal. It's a definition includes any agreement which restricts or likely to restrict the present or future, restricts or likely to restrict by any method the persons or classes of persons to whom the goods are sold or to whom the goods are bought. Means they are restricting from the person there whom the goods should be bought, from whom the goods should to be sold. They're restricting that thing, then it is still refusal to deal, the name itself says. And coming to the next one, that is resale price maintenance. It includes resale price maintenance. Means, for example, you'll see an example here, and a person is there, for example, assume A is a supplier, B is a purchaser, and B is a commercial seller, retailer, and he wants to sell to other consumers or other persons, right? And A has sold goods to B, and in that A imposes some condition that you should not sell these goods less than this price, particular price fixed by A, then B, then that particular transaction is said to be resale price maintenance. There is one exception here, in that if A says that if you should not pay, you should not sell this product for a price more than, not less than this or less than this price, then it is not a resale price maintenance. We'll see the definition here includes any agreement to sell the goods or goods on condition that the price is to be charged on the resale by the purchaser shall be prices stipulated by the seller unless means that particular price, the below that price the purchaser shall not sell, then it is a resale price maintenance. There is an exception unless it is clearly stated that the price lower than the prices may be charged. And in that also there is a statement that below that particular price also the purchaser can resell, then it is not a resale price maintenance. These are the types of agreement. What are the types of agreement? The tie-in arrangement, exclusive supply arrangement agreement, and exclusive distribution agreement, refusal to deal, and resale price maintenance. For example, in ICA, they will ask one particular case study and they will ask whether under which type of a particular thing this thing is falling under. And also there is an exception to the anti-competitive agreement. Nothing contained in this section shall restrict the right of any person to restrain. Restrain here means measure or condition that keeps someone under control. Means any person, the right of any person to restrain any infringement of or impose reasonable conditions as necessary by protecting any rights of which have been conferred upon him under the following acts. For example, if any person is having some copyright or any content, that content has been conferred upon, that content right has been conferred upon that person by any of the act, then such person can restrain or can impose such conditions, then it will not be said to be anti-competitive agreements. What are the acts that confer the right to that particular person is the Copyrights Act 1957, the Patent Act, the Trademark Act, the Geographical Indication of Goods Act, the Designs Act, the Semiconductor Integrated Circuits Layout Design Act 2000. Right, these are the six acts, right? That is what are the acts: the Copyright Act, Patent Act, Trademark Act. First three are related to the copyright, patent, trademark. Intangible, the geographical indication of goods means the geographical particular area. The Designs Act, that Semiconductor Integrated Circuit Layout Design Act. Right, if these acts gives any power to particular person, then that person can restrain any infringement or such person can impose such conditions, then that agreement between that person and any other person shall not be deemed to be as anti-competitive agreement. There is an exception given under section 3 subsection 5 of the Competition Act 2002. And also the second exemption is the right of any person to export goods from India to the extent which the agreement relates to the production, supply, distribution, control of goods or provision of such export. Means the right of person, even though if any agreement entered between the person here and outside person, he can export, that will not be considered as anti-competitive agreement towards the particular extent of production or supply of goods which are going to be exported. These are the exception, these are the exemptions of anti-competitive agreement as per section 3 subsection 5, right? Right, and coming to our next topic, that is abuse of dominant position. Abuse of dominant position has been defined in section 4. For we'll see the definition of that is meaning of the terms abuse of dominant position, the meaning of the term dominant position, and we'll see the meaning of predatory pricing. Coming to the meaning of the dominant position means a position of strength. Means we'll say the dominant, some person is dominant because he has some strength in him, whether it be either may be controlling or any other manner. The opposite of dominant is submissive, right? We'll see the definition and meaning here. The dominant position means the position of strength enjoyed by any enterprise in the relevant market in India, which enables it to operate independently of the competitive process of prevailing in the relevant market or affect its competitor or consumers of the relevant market in its favor. Like these are the keywords here is the dominant position means the position of strength. The position of strength enjoyed by what? Enjoyed by an enterprise, which enables it to operate independently, means he can operate in that enterprise can operate independently of the any competitive process prevailing in that market, or it affects means the position that enterprise position is affecting its consumers. Its consumers or competitors, means other competitors who are in the market and other relevant market in its favor, means he is making them, he is affecting those consumers or he is affecting those competitors, or he is making use of his position, dominant position in its favor, then such position is called as dominant position, right? And coming to the next one, predatory pricing. Predatory pricing means the sale of goods or provision of services at a price which is below the cost as we determine the regulations of production of goods or services with a view to reduce competition or elimination of the competitors. For example, see, there may be some minimum price for any product that may be given by the regulations or any regulations given by any act. Some minimum price will be there. If any enterprise is following the below the price with a view, the intention should be to reduce competition or eliminate the competition, then such pricing strategy is called predatory pricing. What is that? We once again see predatory pricing means the sale of goods or provision of services. It may be goods or services at a price which is below the price which have been regulated, which have been determined by the regulations of production of goods or services. What the main motto with a view to reduce competition or eliminate the competition, then such thing is called predatory pricing. And coming to the next, that is section 4. The prohibition on abuse of dominant position. No enterprise or group shall abuse its dominant position. Means any enterprise is a dominant company. It can be dominant, it can be dominant in the market, but it should not abuse that dominant position. If it abuses that position, then it will be void, right? That agreement or that thing will be made to the inquiry, and then some pertinent orders will pass by the Competition Commission of India. We'll see that later. And coming to this abuse of dominant position, meaning of abuse of dominant position: when the enterprise, when a dominant enterprise is said to be abusing its dominant position, there are 5 points for this. There shall be abuse of dominant position if an enterprise of the group, what is the 5 points? Directly or indirectly impose unfair or unfair or discriminatory conditions with respect to the sale or purchase of goods, and conditions unfair or discriminatory price of goods. This is one condition. The first condition is related to unfair or discriminatory. If any enterprise is directly or indirectly imposing unfair or discriminatory conditions on the sale or purchase of goods or on the price of such goods, then it will be said as abuse of dominant position. That is one condition. Coming to the second point, that is it limits or restricts the production of goods or provision of services or technical or scientific development relating to goods or services which is prejudicial to the consumers. Right. The second point is like that enterprise is restricting or limiting the production of goods or services. We have already seen that is we already seen this point in our definition of cartel. Right, and our definition of cartel, and also per se anti-competitive agreement, the same. The limits are restricting the production of goods or provision of services or market thereof. Means if an enterprise based on the dominant position is restricting the goods production, then it will be said to be as abuse of dominant position. And one more thing is like it limits or restricts the technical or scientific development relating to goods or services which is prejudicial to the consumers. Right, it is it is restricting the use of scientific development by any other person. It has to use, then also it is said to be abuse of dominant position. That is 2 points. The first point is unfair or discriminatory conditions of price, sale of goods or price, and second one is limits or restricts the production of goods and scientific and technical development which is prejudicial to the consumers. And coming to the third point is indulgence in practice or practice resulting in denial of market access in any manner. Right, that enterprise is in an activity or a practice which is making denial of market service. See, if you are old syllabus student, like we can know that in our ISCA, that is denial of service attack. Right, if that any particular website that should not be access to the original intended users, what hackers will do is they will request that to the website multiple times from different users. They will hack that website, and that website inadvertently becomes not accessible to the intended use. That is denial of service attack. Right, and coming here the same thing, that is any indulgence in practice or practice resulting into denial of market access, means that that enterprise which is having a dominant position is using its power for denying market access to that particular person, that is consumers or the competitors, whatever may be in the market manner. That is the third point of abuse of dominant position. If any enterprise is doing that, it is said to be dominant position, abusing its dominant position. And next, fourth point is make conclusion of contract subject to the acceptance by other parties of supplementary obligations which by the nature according to the commercial usage have no connection with the subject matter of the contract. For example, enterprise is there, A limited enterprise is there, and B limited enterprise is there, like, and C limited enterprise is there. Like here in this market, A limited is dominant position. A limited is having dominant position, and it has entered into contract with B limited, and the contract is still pending. Right, in this particular case, the conclusion of this contract between A limited and B limited will be made only upon some conditions imposed by A to B, that B limited should follow the supplementary obligations given to it to the C. Means that the A limited will impose conditions to B that you have to do these following things, then only this particular contract which is pending will be concluded, and the conditions mentioned by A to B shall not be subject matter of this particular contract between A and B. Then this particular entire scenario is abusing the dominant position. Right, this is an example for this. The fourth point, it makes conclusion of contract subject to acceptance by other parties of supplementary obligation which by the nature or according to the commercial usage have no connection with the subject matter of the contract. Means that condition of supplementary obligations imposed by A to B does not have any connection with the subject matter between A and B, the main contract. Right, this is the abuse of dominant position. Coming to the fifth point, the user sets dominant position in one relevant market to enter into or protect another relevant market. Means there are two markets will be there. In that A limited is in dominant position in only one market, and in that particular market it is using that dominant position to enter into new market, or it has already been another market and it also protects its position in another market by using the dominant position in this particular market. Then also that such type of activity is said to be abusing of dominant position. What are the 5 activities? The unfair or discriminatory conditions of sale of goods or services, that is and also price. And next one, the second condition is limiting restriction of production of goods services and scientific and technical development, which is prejudicial to the consumers. And the third point is intelligent practices, which are denial of market access. We are linked with ISCA subject. And the fourth point is conclusion of contracts with supplementary obligation, which are not commercially or any other manner related to the subject matter of the contract. We have discussed an example: A limited, B limited, and C limited. And fifth point is jumping from one market to another market using the abuse of dominant position. That is using its dominant position in one relevant market to enter into or protect the other element. These are the 5 points of dominant position. So we have discussed about the anti-competitive agreements and abuse of dominant position. Next we are going to discuss about the inquiry into this particular competitive agreements and abuse of dominant position. In this nature, what we are going to discuss, what we are going to inquire, like the commission, the generally commission here, the Competition Commission of India may make an inquiry to determine as whether the provisions of the section 3 or section 4 have been contravened. Like these Competition Commission of India will make an inquiry that whether this section 3, that is anti-competitive agreement, or section 4, that is abuse of dominant position, has been contravened by the particular enterprise persons or not. How, when this particular Competition Commission of India will inquire, what are the cases, what are the grounds, and who will file to inquire? Like there are 3 cases. Like the Competition Commission of India on its own motion, that is suo motu, it can make an inquiry, or else on the receipt of any information in such manner accompanied by such fees as will determine the regulations for any person, consumer, competitors, or association or trade association. Right, means any person. Like it can inquire on its own motion, and it can inquire on any information received from any person, consumer, competition, or trade association, or consumer association, whatever it may be. And also on it is if a reference is made by the commission, reference is made to the commission by the central government, state government, or statutory authority. Like these are the 3 points. The Competition Commission of India can inquire into the matters related to the anti-competitive agreement or anti-competitive agreement as per section 3, or abuse of dominant position as per section 4. What are the 3 cases? On its own motion, or by any person, that is consumer, competitors, trade association, consumer association, or any reference is given to the commission by the SG, that is state government, CG, central government, or statutory authority. Here the important word is statutory authority, because here only it is given. Even statutory authority can make a difference to the Competition Commission of India. In that case, the Competition Commission of India will carry inquiry whether any transaction or activity is contravening the section 3 and section 4, right? Right, and this inquiry is and the Competition Commission of India has started inquiry, and it has to see whether there is a contravention of section 3 and section 4. For this purpose, they have to see for contravention of section 3, that is anti-competitive agreement. They have the key word is appreciable dominant, appreciable adverse effect of competition, determining the appreciable adverse effect of competition. The commission shall follow these particular things for determining whether that particular agreement is having appreciable adverse effect on competition or not. The commission shall, while determining whether an agreement has an appreciable adverse effect on competition under section 3 in India, have due regard of all or any of the following factors. For determining that it is whether having any appreciable adverse effect on competition or not, it has to do the following 6 points. With that, it has to take care of these following 6 points, or any 1 point. If it is falling under, then it will be said to be as that is appreciable adverse effect on competition. The first point, the first 3 points are positive, negatively talking, and second three points are positively talking, right? And we can remember like that. The first 3 points are relating to the competitors, like entry barriers, creation of barriers to the new entrants in the market, and driving existing and competitors out of the market, foreclosure of competition by hindering entry into the market, right? These are the negative, like creation of barriers. They're creating barriers for the new entrants, or what are the existing competitors are there, they're kicking out those existing competitors, or they're closing the ahead, like they're restricting the entries. Like first one case, they are creating barriers, means even though the new entrants can come to the market, but they're creating some barriers. And second one is the existing competitors, they are kicking out those existing competitors. Any agreement is such like that. Or the third point is foreclosure, they are closing ahead, they are not allowing any new entrants to come. These are the 3 negative conditions, and the 3 positive conditions are accrual of benefits to consumers. What are the benefits that may be accrual to the consumers? And improvements in production or distribution of the goods or provision of services, any improvements or any promotion of technical, scientific, economic development by means of production, distribution of goods or services. Like the 3 positive things are accrual of benefits and improvements, promotion, accrual of benefits, improvements in what production, distribution of goods or services, promotion in what technology, right? If these 6 points the Competition Commission of India will have a due regard whether to determine whether the particular transaction is having a appreciable adverse effect on competition or not. If it is having appreciable effect of competition, then it will pass orders respectively. Right, and coming to the next one, determine whether the enterprise enjoys the dominant position or not. For the same thing, the commission has to take some due regard with certain points. What are the points? The commission shall, while inquiring whether the enterprise enjoys a dominant position, as per section 4, have due regard to all if any of the following particulars. Following factors means the enterprise has to see the following. That commission has to see the following particulars. What are the following particulars? That is the market share of the enterprise, the size and resources of the enterprise, the size and importance of the competitors. Like what is the particular market share of the enterprise to abuse the dominant position, and what is that size and resources, market share, size and resources, size and importance of the competitors in the particular relevant market. Any competitors are there, and what are their size and what are their importance to determine whether this particular enterprise is using abuse of dominant position or not. And also the economic power of the enterprise, including commercial advantages over the competitor, means if that enterprise is having any economical power over the other enterprises or not. Any vertical integration of the enterprise as a sale of service network of such enterprise, the Competition Commission of India will see that vertical integration is there or not. And also dependence of consumers on the enterprise, means how much the consumers are depending on this particular enterprise, they will analyze. And also they will see the monopoly or dominant position, whether acquired as a result of statute or by virtue of being government company or public sector company. Means like, see, if that particular enterprise is enjoying dominant position, they will see whether that the position that enterprise has got from the statute of act, or by being a government company or being a PSU, it has got a dominant position that the Competition Commission will analyze. And entry barriers, including the regulatory barriers, financial risk, high capital cost of capital, marketing entry barriers, technical entry barriers, economic of scale, high cost of substantive goods and consumers of services. Like these entry barriers are there, and also with that Competition Commission will analyze. And countervailing buying power, market structure and size of market. What is the market structure and what is the size of the market? The Competition Commission of India will analyze, and they will determine in that case the particular enterprise is abusing its dominant position or not. And social obligations and social cost, relative advantage, any social obligations are there, whether that enterprise is following that or not. Any social cost is there, any relative advantage by the contribution to economic development by enterprise enjoying a dominant position, having likely to have appreciable effect on competition. Like that, any relative advantage is being enjoyed by that particular enterprise, they will analyze. And any other factors, right? They will see the following factors to see whether that enterprise is having dominant position or not. What are the factors? Market size of the enterprise, market share of the enterprise, market size of the enterprise, that is size and resources of the enterprise, and size and resources of the other competitors in the particular market to determine whether this particular enterprise is having more market size or not. And economic power, vertical integration, dependence of consumers, monopoly, entry barriers, countervailing buying power, social obligation, social cost, relative advantage, any other factors, right? These are things about to determine whether the particular company is abusing of dominant position or not. If it is found that the Competition Commission of India that enterprise is abusing dominant position, then the Competition Commission of India will pass orders respectively, right? Right, and coming to the next one, that is determining relevant market. The Competition Commission of India will define the relevant market based on the following thing. For determining whether a market constitutes a relevant market for the purpose of this act, the Commission shall have due regard to the relevant geographic market and relevant product market. There are two types. The Competition Commission of India will analyze these two particular things, that is relevant geographic market and relevant product market, and they will determine whether the particular market is a relevant market as per according to this act or not. Coming to the relevant geographic market, for determining whether the market is having relevant geographic market, the Competition Commission of India will have due regard to any or all of the following activities. Right, what are the activities? There are about 2 plus 4 plus 2. That is 8 activities are there, 8 factors are there to determine whether that particular is relevant geographic market or not. First of all, that is regulatory trade barriers and local specification requirements. Those two will remember one thing. Regulatory, one part, regulatory trade barriers, local specification requirements, right? Their trade barriers are there, and any local specification requirements. We are discussing about a relevant geographical market. So the first 2 points are about relevant geographic area, that is regulatory trade barriers or local specification requirements. The next 4 are regarding the process, like national procurement facility, national procurement policies and adequate distribution facilities, transportation cost, languages, like what are the procurements they are getting and how their distribution is going to happen and how the transportation is going to happen and what are the languages they can be. And is geographically different language will be there, right? These are the first one is 2 entry barriers, and the second one is local specification requirements, and the third, that is the second set is 4th set, that is national procurement policies adequate distribution facilities, transportation cost, language. And next two such as consumer preferences and need for secure, regular and supplies or rapid after sales services. This is about a relevant geographic market. The commission will analyze these factors and they will decide whether the particular market is a relevant geographical market. And after satisfying this relevant geographical market, we have to see the relevant product market. For the Competition Commission of India shall determine the relevant product market have to due regard or any of the following cases factors, right? There are around 6 here, and we will see the first 3 as one set and second 3 as another set. The first 3 is related to the product and its physical characteristics and its price and its consumer preferences, right? The physical characteristics are end use of the goods and the price of the goods or services and consumer preferences. This is the first set, and second set is about exclusion of in-house production, whether any in-house production is a particular product or not, or existence of specialized producers, any specialized producers are their particular product or not. And next one is classification of industrial product. We will classify the product into 2 different categories based on the industry standards. These are the 6 points. First set is about the product. We will classify the product into physical characteristics and the price of the product or goods or services and the consumer preference. And the next one is in-house production or is there or not, and specialized producers are there or not, and the industry classification of products is being done or not. If these two conditions, that is relevant geographical market and relevant product market, is done, then they will analyze these two and they will come to a conclusion that particular market is a relevant market or not, right? Right, and coming to the next part, that is orders by the Commission after inquiring into the agreement or abuse of dominant position. Means the Commission of Competition Commission of India has inquired about the has inquired about the anti-competitive agreements and abuse of dominant position, and if it comes to a conclusion that these activities are contravening to the section 3 and section 4, it can pass the following orders. There are six type of orders that it can pass, and seventh is residuary part. The 6 orders that it can pass all or any of the following orders. What the Competition Commission of India can pass. The Competition Commission of India can pass the 6 orders. We will classify into two sets. First set is discontinue. It orders the enterpriser person to discontinue that agreement, and second is it orders the enterpriser person not to re-enter or abuse of dominant position once again, and it can order for penalty. These are the 3 things. First, it shall order for discontinue of the agreement, and it order for not to re-enter into any such agreements or not to abuse this dominant position again. And third one is penalty. This is the first set. It can impose order for penalty, and the second set is that the 3 points, that is it can modify. It can make direct the enterprise concerned shall stand modified. It may direct the agreements shall stand modified to the action in the manner specified with the in order. Means the agreement which have been anti-competitive agreement or are there right a contravention, then that Commission of India can pass orders for modifying this agreement also for compliance with the section 3. And the next one is abide by such other orders. Means the enterprise concerned will abide by such orders and the Competition Commission of India will pass right. And next one is cost. It may order for payment of cost if any, for inquiring if any cost has been incurred by the Commission. It may order for payment of cost, or if any damage are incurred by any other person and the other person comes to approach to the CCI, then it can order for damage of the payment of cost. And next one is residuary, that is to pass such orders as with deemed fit. Right? What are the orders? There are 6 type of orders. The Competition Commission of India may pass all or any of the following orders. It may direct any enterprise or person to discontinue. The first one is discontinue or not to re-enter. The second one is not to re-enter. The third one is penalty, and fourth one is regarding the agreement modification. Fifth one is abide by such other orders that the Competition Commission of India is passed to comply with its directions. It may order for payment of cost, that is abide cost, and next one is our right, this residuary point. There are 7 types of orders that the Commission of India can. I think this question is expected this time, right? And what are the orders the Commission will pass after inquiry? There are 6. The first one is discontinue, re-enter, penalty, modify, abate, cost, residuary. Right, we have discussed about the penalty. What is the penalty? Like if the Competition Commission of India imposes penalty on these contravention of section 3 and section 4, it shall impose a penalty of shall not be not more than, means it can be up to 10% of the average of turnover of the last preceding 3 years upon each year the parties involved of the contravention. Right, last 3 previous years we have to take, and the turnover last 3 previous years turnover you have to take, and the penalty shall not be more than 10%. When the penalty shall be up to 10% of the turnover of the preceding 3 years to each of the parties, right? That is one case. And second case, if any cartel is involved in this particular section 3 section 4 contravention, then for particular each distributor, each supplier, the penalty is being given. That penalty is the higher amount of the following, that is three times of its profit for each year of its continuance of such agreement, or 10% of its turnover for each year of continuance of its such agreement. Means three times what are the profits earned by each distributor, each supplier in this particular year continuance of this agreement, that is three times the profit, or 10% of turnover of the continuance of that agreement if each year, whichever is higher the penalty. The first penalty is 10% of a turnover of the average of preceding 3 financial years for each of the parties, and if any cartel is involved, to each supplier, to each distributor, to each person, the penalty is higher of the following: three times the profit in the year of continuance of the agreement, and 10% of the turnover in each year of the contents of the agreement. Right? This is about the orders of inquiry into the agreement of abuse of dominant position. That is section 27, one of the important section expected this time. Right, and coming to this one, we have one topic in our this dominant position, that is division of enterprise enjoying dominant position, that is section 28. When can the commission order for division of enterprise? The commission may by written order direct the division of enterprise enjoying the dominant position to ensure that such enterprise does not abuse its dominant position. Means the Commission of India can make an order for division of the enterprise, so that such that the enterprise cannot abuse its dominant position. There are around 6 type of orders that can Commission of India for the division of enterprise. We will classify these orders of Commission of India for dividing this dominant position of enterprise into two sets. What are the two sets? The first set we have 3 points, and second set will have 2 points, and the last one is for any other residuary matter, right? And the first one is relating the transfer or vesting of property rights and obligations and liabilities or obligations. Next one is the adjustment of contract either by the discharge or reduction of any liability, obligation, or otherwise. Next one is creation, allotment, surrender, or cancellation of any share, stocks, and securities. Like, see, the Commission of India will pass an order for transfer of the properties of the enterprise, rights, obligations, liabilities, such that it can be division will be done, and such enterprise shall not abuse its dominant position. And the second one is it will make an adjustment of contracts either by discharging the contracts or reducing any liability or obligation or otherwise. Right? The Commission of India will pass an order for adjustment of the contract entered by the enterprise, either by concluding the contract, means either by discharging the contract or reducing the liability in the particular contract, so that the particular enterprise shall not abuse its dominant position. This is the second point. First point is a transfer of vesting property rights and obligations, so that can be adjustment of contract either by discharging or reducing the liability. And the next one is the creation or allotment, surrender, or cancellation of any share, stock, or securities. Means that particular enterprise is having share stocks, right? Whether by creation or allotment or surrender of any cancellation of any shares, means the shares are cancelled, such that so that Commission of India will pass an order in respect of this particular point, so that the enterprise will not abuse its dominant position. This is the first set. The first point is transfer, and the second transfer of vesting of property, and adjustment of contracts, and creation, allotment, surrender of share, stocks, and securities. And the next 2 points related to the formation or winding up. Right? The formation of winding up an enterprise means either it will form a new enterprise, or it will wind up any particular enterprise for this particular order, division of enterprise order. And next one is the amendment of the memorandum or articles of any other instruments regulating the business of enterprise. Means it will amend, it will make an order to amend the memorandum. Please go and amend your memorandum of articles of association of that enterprise, so that that enterprise cannot abuse dominant position. What are the two sets we have? The formation of enterprise and binding of an enterprise, and amending the memorandum of articles of association. And the last one is residuary, that any other matter which may be necessary to give effect to the division of enterprise, that is residuary point. In the following 3 points, the 3 plus 2, that is transfer of vesting property, adjustment of contracts, creation, allocation of shares and securities, cancellation of shares, formation or winding up, and amendment of articles, and others miscellaneous. Right, and coming one more thing, important point is provision of composition of office. Because of this division of this enterprise, the particular the offices of the enterprise will be there, right? They will have to vacate their office, and because of this reason, any employee, any officers of this enterprise has to vacate his office, and he is a loss of office, right? This particular compensation will be paid to that particular person or not is the question. The answer is no. The commission to the particular officer of the person, because of division of enterprise order passed by the Competition Commission of India, shall not be paid. If you see this loss of commission, we have come across in our Surfacing Act also, and in as well as our Companies Act, that is section 191, and and 202 is relating to the competition, that is loss of competition to the those persons like key management persons, and 191 is for general purpose. There are some transfer of shares and undertaking will there, particular point will be there in the 181. In 181 and 202 compensation can be paid, but whereas in case of Surfacing Act, if you remember Surfacing Act, it is borrower, the borrower management is taken over by the asset reconstruction company or the security debtor. In that particular case, because of that management takeover, the director's office, managing director position, she has to vacate. The loss of office has been suffered by them. In that particular case also compensation is not paid to them in Surfacing Act. As well as here in Competition Act also, the compensation will not be paid because of loss of office due to the order passed by the Competition Commission of India in respect to the division of enterprise. Right? This is one of the important point here, and the division of enterprise has been completed. Right? And we have a combination. Right? Next we are going to the combinations as well, section 5. Right? Right, and coming to the next, that is the combination. In combination, we'll see the combination is divided in section 5 of the Competition Act 2002. Combination, there are 5A, 5B, 5C, and 5A is about acquisition of control by enterprise by persons, or acquisition of 5B is about acquisition of control by persons already having control over the another enterprise, and 5C about merger or amalgamation. 5A is about the first time acquisition, and 5B is about the person is already having acquisition control and of another enterprise, and 5C is about merger or amalgamation. Right, these are the 5A and 5B combination, and we'll see individually and as a group. Right, coming to the first one, individually, any enterprise after merger or amalgamation or parties to the acquisition, or enterprise whose control has been acquired along with its enterprise over which acquirer already has control, means then 5A, 5B, 5C individually we have to check the limit. And here if we will divide into two types, have in India or outside India. Have in India or outside India. The first condition for have in India is we'll use the rule of multiple of 3, that is the assets exceeding 2000 crores and the turnover exceeding 2 into 3, that is 6000 crores in India. If it is in India or outside India, if that enterprise is having in India or outside India, then the following conditions to be checked. If the assets in outside India is $1,000 million, and here the condition is used, and assets in India should be 1000 crores or more, 1000 crores or more, and in the turnover criteria, or the turnover is in outside India, it is multiple of 1 into 3, that is $3000 million, and in India the turnover is 3000 crores or more in India. Right, once again the individual entity will see have in India, the assets and turnover in India or outside India. First one, have in India, the assets is 2000 crores exceeding 2000 crores, and the turnover in 2 into 3, that is 6000 crores exceeding 6000 crores, or have in India or outside India. First condition is assets we have to check in outside India is exceeding $1000 million, and is used, and assets in India are 1000 crores or more. And coming to the R condition, next condition, have in India or outside India, that is turnover, that is $3000 million exceeding $3000 million, and in India the turnover is 1 into 3, same, that is 3000 crores or more. If you have to be careful, only in second point, that is have in India or outside India, it is equal to if the assets are in India equal to 1000 crores or more. If it is equal to 1000 crores, it is okay. If it is if or more also, it is okay. And turnover also 3000 crores or more, but in the next above conditions, that is only exceeding is given, exceeding 2000 crores, exceeding 6000 crores, exceeding $1000 million, and exceeding $3000 million. Coming to the group to which the enterprise would be would belong after merger or amalgamation as per section 5C, or parties to acquisition would belong after acquisition 5A, or the enterprise whose control has been acquired would belong after the acquisition 5E. Means that here we will see as a group that the same will take class between two categories, have in India and have in India or outside India. Have in India, we will check the same multiple of 3 condition. We have to see have in India that assets is exceeding 8000 crores, and 8 into 3 is 24, the turnover is exceeding 24 crores. It have in India or outside India, the second category we will see the assets exceeding $4000 million, and the assets in India is 1000 crores or more, the same conditions for individual entity. And coming to the R condition, another condition, the turnover is multiple of 3, that is 4 into 3, that is $12,000 million, and is used, and turnover is 3000 crores or more in India. The same conditions we can see that if you remember multiple of 3, if you remember 2 into 3 is 6, 1 into 3 is 3, and 8 into 3 is 24, 4 into 3 is 12. This is a shortcut for remembering this combination. Then such enterprise will be said to be in a combination. Right? This is the definition of combination as per section 5. And coming to the regulation of combination, means section 6 deals with the regulation of combination, that is parties to combination has to inform the following things. The parties to combination notice of a proposed to combination to the CCI Competition Commission of India within 30 days of approval of merger amalgamation by the board, and 5C or execution of agreement or document of acquisition under 5A 5C. That is, any parties to the combination has to file a notice of proposed to combination to the Competition Commission of India within 30 days. That is after 5A, if it is 5A, that is 5A or 5B, the execution of agreement or document of acquisition of control within 5 days from that date, or in case of 5C, then merger amalgamation, the approval of merger amalgamation under 5C, that is from the within 30 days we have to send a notice of proposed combination to CCI. Then the CCI will follow the section 20, section 29, section 31, that is section 20 is inquiry, section 29 investigation, section 31 is order. Then the CCI will pass an order on section 31 within 210 days, right? If it doesn't pass order within 210 days, then the combination shall take effect after 210 days. Then within 210 days, the combination may be approved, or combination may not be approved. The combination, if it is combination is approved, the combination shall take effect from the date. If the combination is disapproved or do not have adverse effect, then the combination will not affect, and the Competition Commission of India will pass such order in respect of that, right? And coming to the consequence of failure to give notice of combination to the commission means the parties to the combinations who have under the 5A, 5B, 5B, 5C have not given notice to Competition Commission of India within 30 days, right? Then what is the penalty? The penalty will be 1% of total turnover or assets, whichever is higher shall be imposed by the commission. 1% of total turnover or assets, whichever is higher shall be imposed by the Competition Commission of India, right? And one more thing is regulation of combination, that is section 6 shall not apply to share subscription or financial facility or any acquisition by public financial institution, foreign institutional investor, bank or venture capital fund pursuant to any convenient of a loan agreement or investment agreement, provided the details of the acquisition are filed with the commission within 7 days of acquisition. Like this particular section 6 is not applicable to this following things, that is the public financial institution, the foreign institutional investor, the bank or venture capital fund pursuant to any means these they have acquired, they have made subscription of financial activity, then these banks financial institutions have to submit a loan agreement, like loan agreement or investment agreement, provided the details of provided the details of the acquisition, means what are the acquisition they have made, then the details will be filed with the Competition Commission of India within 7 days of acquisition. Then this particular section 6 will not apply to this particular public financial institutions, foreign institutional investors, bank or venture capital fund, right? And there are some certain exemptions given to the combination, that is section 5 exemptions to the particular sections, that is section 5 combinations. So the first point is a group is having less than 50% of voting rights of an enterprise, then this particular group shall not become under this purview of combination for a period of 5 years from the date of 2016 notification, means that exemption is available for a period of 5 years from the date of official gazette notice, that is 2016, that is 4th March of 2016. From the date to 5 years, if any group which exercises less than 50% of voting rights in enterprise is exempt from the provision of this section 5. We have to remember the group is exercising less than 50% of voting rights, that exemption is available for the group, that is section 5 is not applicable, and the exemption period is 5 years from the date of official gazette, that is 2016, 4th March 2016. And coming to the next exemption, that is assets turnover being required, means for example the 5A, 5B, 5C, right? 5A is there, right? 5A is for acquisition of control enterprise by any person, and 5B is for acquisition of control by person already having control over another person, and 5C is merger amalgamation. In this process of if a person is if that enterprise is acquiring assets turnover, if the person asset turnover being acquired is less than or equal to the assets is less than or equal to 350 crores, and the turnover is less than or equal to 1000 crores, then this particular section 5 is not applicable to this combinations, right? So the section 5 is not available to this enterprise. That means that particular acquisition should not come under section 5, right? And also the same exemption is available for a period of 5 years, that is from the date of official gazette notification, that is March 2017, 27th March 2017. From that date to 5 years, this exemption is available. What is the exemption? 5A, 5B, 5C, if the assets are turnover being acquired, if the asset is less than or equal to 350 crores and the turnover is less than or equal to 1000 crores, then this particular combination section 5 is not applicable to the enterprise, right? And also one more thing, see, while calculating this turnover and assets criteria, what value you have to take. For example, if any enterprise is acquiring another company, then another company turnover we have to take, right? That combination, that turnover or assets value should be taken from the book value of the audited financial statements. If that audited financial statement is not available, and we have to take the previously audited financial statements, and then we have to reduce the sufficient depreciation from that, and then we can take these values. These values will include like the trademarks, copyrights, goodwill, patent, permitted use, collective mark, registered proportionate, registered trademark, registered user, homonymous geographical indication, design, layout, and all these things the assets will include. And also the coming to the turnover part, the turnover shall be certified with the statutory auditor on the basis of the last available audited accounts of the company, right? Based on this, the turnover will be certified with the statutory auditor, and assets, if it is not audited, will take the respect to previous balance sheet, and the assets will reduce a sufficient amount of depreciation. It will take the value, right? Right, and also the certain exemptions the central government has issued in the public interest. There are the following exemptions has been by the central government in the public interest, that it exempted the reconstitution of a nationalized bank, as the Banking Companies Act, that is Acquisition of Transfer Undertakings Act. That means that if the right, the certain exemptions are in the public interest, the CG will give. That is the reconstitution of nationalized bank under the Banking Act, Banking Companies Act. See, if any banks are reconstituting, then this particular combination will not apply for a period of 10 years from the official history, that is 2017. From the date set 10 years, this even the national banks come to a combination, then the section 5 will not apply. And also the the same, like the central government, the public interest exempted regional rural banks in respect of which the central government notification, and the Regional Rural Bank Act 1976. For this also the combination of section 5 will not apply for a period of 5 years from the date of official notification, that is 2017, from that 5 years. And also see, the central government has public interest exempted all cases of combination of section 5 of the act involving central public sector enterprises operating in oil and gas sectors and the Petroleum Act 1934 and the rules they are made under. Here also, if this enterprise falls under this category for a period of 5 years from the date of official notification, that is 2017, 5 years, the combination will not apply to this particular enterprises, right? This is about exemptions to the enterprises, right? And coming to the next point, that is relation to the inquiry into the combination means right, the nature of inquiry. The commission may make an inquiry to determine that the combination has caused or likely to cause the appreciable adverse effect on the competition of India. Means because of any combination, whether there is any appreciable adverse effect in India on competition, the commission will inquiry. When the commission of India will inquire this particular combination, when on its own motion it can do, or else at a receipt of notice under section 6 subsection 2 it can inquire. See, in section 6 subsection 2, that is the parties to the combination only shall have to inform to the Competition Commission of India within 30 days, right? At that time, or sumo moto, it can go for inquiry of the commission, inquiry of the combination, whether that particular combination is having any appreciable adverse effect on the competition in India, right? And what is the period of limitation for making inquiry? The Competition Commission of India shall inquire not after any inquiry after the expiration, not initiate any inquiry after 1 year from the date of combination has taken effect. Means the combination has taken effect within 1 year, the Commission of India has to inquire under this section 20. After 1 year, the inquiry cannot be done, right? And determine the effect of combination or competition. In this case, we have learnt in our dominant position, due to determining the abuse of dominant position. Some points we have done, right? The same points we can write here, but we can replace the enterprise word with the combination, right? For the purpose of determining whether the combination would have the effect or likely to have an appreciable adverse effect on competition in relevant market, the Competition Commission of India shall have due regard to all any of the following factors: the actual potential level of competition through imports in the market, the extent of barriers, the level of combination in the market, degree of countervailing power in market, likelihood that the competition, because of the combination, the members who are entered into the combination can increase the prices, extent of effective competition likely to sustain in market, and extent to which the substitutes are available or likely to be available in the market, market share, relevant market share, nature and extent of integration in the market, and possibility of failing business, relative advantage, like this. The same point which I have done for determining this dominant position, the same points can be done here, can be written here. No, there is not a problem. And coming to the next one, that is investigation procedure for investigation of a combination. So, see, after the Commission of India prima facie has an opinion that this after inquiry, the Competition Commission of India has come to an opinion that this particular combination is having appreciable adverse effect on the competition within the relevant market in India, then it can give notice to the parties to the combination within 30 days to respond from the receipt of date notice, right? It will give the notice to the parties to the combination. Please respond within 30 days. Why we should not initiate investigation proceedings in this matter? See, after receipt of that representations from the parties, then this Competition Commission of India will ask for a report from the Director General, and such a report shall be submitted by the Director General within such time and will be prescribed. Right. The first thing is the Competition Commission feels that this combination is having appreciable adverse effect. Then it will issue notice to the parties of the combination. Then the parties of combination within 30 days has to report to the Competition Commission of India, and after receipt of that report from the parties, the Competition Commission of India will ask report of the Director General, and the Director General will submit the report within prescribed time. Right. After receiving this, after receiving that from the parties and the report from the Director General, if still the Competition Commission of India prima facie thinks that the combination has appreciable adverse effect, then within 7 working days from the receipt of information from the parties to the combination or the report from the director, whichever is later, it shall issue notice to the parties to the combination. Please disclose the details of combination within 10 working days from the date of receipt of notice. Right. Then the parties to the combination will disclose the combination in the public to the public. Then also the objections against the combination. If any objections will be raised, that objections should be accepted by the Competition Commission of India within 15 working days from the date which the details of the combination was published. Right. And the Competition Commission of India, if it wants additional information, it can ask for the parties to the combination, and such information shall be furnished within 15 days. And after getting all the required information, it will go with the section 30, that is orders of Commission of India and certain combinations. And after the inquiry and investigation, it is proved that the combination does not have an appreciable adverse effect, then the combination shall take place. If it is proven that the competition has appreciable adverse effect, then the competition shall not take effect. Right. Even if that combination has any appreciable adverse effect, then the Competition Commission of India shall ask for modification of the combination. Right. In this modification, the commission proposed the modifications. The commission proposed the modification to eliminate the appreciable adverse effect, and that modification has been accepted by the parties of the combination. Then they shall carry such modification. They shall carry such modification to the combination, and after that, within certain period, it will be accepted. Then see here, the modification has been given to the parties to combination within certain period, but they did not modify the combination. Then it will be deemed to be having appreciable adverse effect, and it shall not take effect. The combination will not take effect. And also, if the case the modification has been proposed by the Competition Commission of India, what if the parties have made a refusal to the modifications? The parties have made refusal. The parties within 30 days of receipt of that modifications have to make an amendments to the combination and report to the Competition Commission of India. Right. See, after receipt of the modification, they have refused the modifications, and they have still make some another amendments that they see. In this case, the parties to the combination, after getting that modification, the refused to the modification, they have made some amendments to the combination, thinking that they deem fit. They will send that amendments to the Competition Commission of India within 30 working days. Right. And what if they did not, they have refused, but they did not make any amendments to that Competition Commission of India and the combination within 30 days, then that combination will be deemed to have a appreciable adverse effect and shall not take effect. Right. What if that amendments have been sent to the Competition Commission of India, the amendment has been agreed with the Competition Commission of India, then the combination shall take effect. What if the refusal of Commission to agree the amendments? That means the Competition Commission of India has refused the amendments of combination. Then what is the case? If the Commission does not accept the amendment submitted by the parties, then the parties shall be allowed for the period of 30 working days. Within such parties shall accept the modification proposed by the Commission. They will have another 30 days working period. If the parties fails to accept the modification proposed by the Commission, see, after refusal of amendment of combination by the parties, then they will have additional next 30 working days to accept the modification of the Commission. Even though still the parties does not accept, then that Commission shall be deemed to have appreciable adverse effect, and the Commission shall not take effect. Right. This is all about the combination. It's a very big one. We have completed our third category, that is transaction category, and coming to the next category, that is appeals category. Right. Right, and coming to the appeals appeals, we have all know the structure is Competition Commission of India, Appellate Tribunal, and Supreme Court. The Appellate Tribunal here is a National Company Law Tribunal. Appellate Tribunal, that is in our Company Act 2013, the same NCLAT is here Appellate Tribunal. And see, if any person is aggrieved of the orders of Competition Commission of India, can make an appeal to the Appellate Tribunal, that is NCLAT, within 6 days from the date of receipt of order. And also, if the competition, if they file after the expiry of 60 days, if the Appellate Tribunal feels that if it is sufficient cause, then the appeal can be accepted, right? And coming to even if the orders of appeals, even if the orders of the appellate tribunal, if any person is aggrieved, that is central government, state government, or competition commission of India, statutory authority, local authority, or any enterprise or any person aggrieved can file an appeal to the against the order of appellate tribunal, that is NCLAT, to Supreme Court within 60 days. Even if the person aggrieved files after expiry of 60 days, if the Supreme Court thinks that there is sufficient cause preventing him to file the appeal, it can accept the appeal. Right? This is about appeal structure, the 60 days, and appellate tribunal. Right? And coming to our next one, that is others miscellaneous, we have power to central government to supersede the commission, and power of commission to regulate its own procedures, interim order, appearance before commission, rectification of orders, and execution of orders of commission imposing penalty. Right? Right, and coming to the first point, that is power of central government to supersede the commission. Right, this supersession of central government we have seen in our SCRA, in Surface, and even in our SEBI we have seen in the supersession. The same copy paste provisions are here in our Competition Act also. The reasons for supersession: if the central government opines that if central government believes that there are three causes for supersession the commission. What are the three causes? The first cause is unable to discharge its functions beyond his control, and persistently makes default, and third condition is public interest. What are the three conditions? Unable to discharge its functions beyond his control, and second one is persistently makes default, and third one is public interest. Right, where the central government is of opinion that the account of circumstances beyond the control of the commission, where the commission is unable to discharge the functions of perform duties imposed on it, or whether the central government believes that the commission persistently made a default in company directions issued by the central government, or discharge its functions or performance or duties imposed on it, or and as a result of that persistent default, the financial position of the company has weakened, has suffered. And the third condition is whether the central government is of opinion that the circumstances exist which render it necessary in the public interest to supersede the commission. Central government has opinion that it is in the public interest to do so, then the central government can supersede the commission in three reasons. So that we are unable to discharge its function beyond its control, and persistently make default because of the financial position of the commission has suffered, and the public interest. Right, and coming to the next conditions for making an order of supersession. Before that order of making supersession, the central government has to give a reasonable opportunity of being heard. That is, a principle of natural justice shall be given to the commission. After getting representation from the commission, the central government shall consider representations, and also the central government will pass the order in the official gazette. The supersession shall not exceed a period of 6 months. The same provision as we have seen earlier in our previous acts. And the effect of supersession. The effect of supersession also same. The supersession means the chairperson and the members of the commission right, has to vacate their office, and the powers and duties vested with the chairperson or members will go to the person who have authorized or appointed by the central government, and as well as the property of the commission will transfer to vested in the central government. Right, and after reconstitution provision also same, it shall be obligated the central government to reconstitute the commission. Accordingly, the central government shall reconstitute the commission or before the expiration of period of supersession. Means that 6 month period, within 6 month period, if the central government believes that the commission can be reconstituted, it can reconstitute the cantonments, that commission. Right, the reconstitution shall be a fresh appointment of chairperson and members. Because of that supersession, any officers or chairperson has been vacated office, that those officers shall not be deemed to be disqualified for reconstitution another appointment. Right, this is about reconstitution. And coming to the laying of document before the parliament. Before the parliament, the following documents shall be laid. The two houses of parliament, that is Lok Sabha and Rajya Sabha. The following documents are the circumstances leading to the supersession, and the notification of supersession issued by the central government, and the full report of action taken by the central government. Or the three documents, the circumstances leading to the supersession, because that in that official gazette the central government will publish in official gazette. Right, in that official gazette also it has to mention the reasons for supersession. The same thing will be laid before the House of Parliament, that is the circumstances leading to the supersession, and notification of supersession issued by the central government. What is the notification issued by the central government, and also the full report of action taken by the central government. What action taken by the central government, how they have reconstituted, and what powers they have exercised. That shall be laid down before the Parliament. Right. Right, and coming to the next one, that is power of commission to regulate its own procedure. The Competition Commission of India has its own power to regulate its own procedures, but that own procedure should be according to the other provisions of this act, and any direction passed by the central government. Means the Competition Commission of India will follow the principle of natural justice. Right, now certain powers of Competition Commission of India as our same powers, our civil court, that is our, we have discussed in our Surface chapter also, SSRR, that is summoning and enforcing attendance of person, examining him on oath, requiring discovery production of documents, receiving evidence on affidavit, which issuing commissions regulation of any public record or document or copy of record document from any office. That is the powers of a civil court. We already know the powers. SSRRID, right? The shortcut. And the external professional advice. This is important point. External professional advice. If the Competition Commission of India thinks reasonable that it can ask for expert of various field, that is economics, commerce, accountancy, international trade, or from any other discipline to assist the commission in conduct of it any inquiry before it, means the Competition Commission of India can take help of the expert. This question has already been asked, right? This question is expected this time. And see what the question will be like. The Competition Commission of India has taken an expert advice based to in the inquiry whether it is acceptable or not. Yes, it is acceptable because the Competition Commission of India can regulate its own procedure and principle of natural justice grounds, right? This is about the power of commission to regulate its own procedures. Right, and coming to our last important point is power to issue interim order. The Competition Commission of India can issue interim orders only if the inquiry is pending before it, and the Commission is satisfied that an act in contravention of Section 3, Section 4, and Section 6, that is anti-competitive agreement and abuse of dominant position, and the combination has committed or continues to be committed, or such act is about to be committed, then only it can pass an interim order restraining the parties to commit any agreements. Like that, it can pass on its pending before the only if the inquiry is pending. The Competition Commission of India can pass interim orders only if any inquiry is pending before it, and the Commission is satisfied that any act is contravention of Section 3, Section 4, Section 3, Section 4, and Section 8, is anti-competitive agreement, combination, abuse of dominant position is committed, continues to be committed, then it can pass interim order. The Commission may temporarily restrain any party from carrying any activity which is contravention of Section 3, Section 4, Section 6, right? And the Commission is empowered to issue interim audit without giving any notice to the opposite party. The Competition Commission of India can give notice, can pass interim order without giving notice to the other party. That is reasonable opportunity of being heard is not there here in this case. And coming to the appearance before the Commission, who will appeal before the Commission on behalf of the enterprise? The CA, the Chartered Accountant, and the Company Secretary, Cost Accountant, or any legal practitioner can attend appearance before the Commission on behalf of the enterprise, right? On behalf of the enterprise or person. And coming to the rectification of orders, so what if the Commission has the past order and there is a mistake apparent from record? There is a Competition Commission of India can rectify that order or not. Section 35 imposes the Commission to rectify any mistake only if such mistake is apparent from record. And also one more thing is that it cannot rectify the substantive part of the order previously passed. It can only rectify the minor part, that is the mistake shall be apparent from record, and it cannot rectify the order, amend the order of substantial part of the order which is previously passed. When can the Commission rectify its orders? What is that? When the Competition Commission of India can rectify its orders on its own motion or any application made by the party to the order, right? This is about rectification of order. And coming to the execution of orders of Commission imposing monetary penalty. See, in this act, if any penalty is imposed by the Competition Commission of India and that penalty is not paid a particular person on whom the penalty is imposed, then the recovery proceedings will begin. The recovery proceedings will be as per the regulations made under this act. And also one more point here is that if the Commission feels that it is expedient to recover the proceedings, it can transfer that pending penalty to the income tax officer, and income tax officer will recover that penalty, right? That is, if the Commission is of the opinion that it would be expedient to recover a penalty imposed under this act in accordance with the provisions of the Income Tax Act 1961, it may make reference to the effect of the concerned income tax authority for recovery penalty as tax due under the Income Tax Act, right? After reference from the Commission to the Income Tax Department, that penalty due will be named as tax due as per the Income Tax Act, and the person on whom the penalty is imposed shall be deemed to be a C of default, and the respective provisions of the Income Tax Act 1961 shall apply. That is Section 221, 227, 228, and 229, 231, and 222 of the said Income Tax Act shall apply, as is a person deemed to be a C in default when the Commission make reference to the Income Tax Authority to recover, right? This is all about Competition Act. I think the video has gone very long. It is about 1 hour 41 minutes, I guess. That's it all for now. Hit the like button, share this video, subscribe to this channel for more updates, right? Thank you so much.